Good evening, everybody, and welcome back to the Wednesday webinar with the Property Law Alliance. As always, it's good to have you with us, and it's good to have our experts with us, Cilna and Bruno. How are you guys doing? Hi, Cilna, how are you?
I'm good, thank you. How are you, Chris?
I'm freezing, and I actually blame Bruno because I'm in Durban, and you guys are in the cold weather in Johannesburg, and Bruno came down last week. And you did bring the cold with you, Bruno. It is
Maybe it's just winter.
Or that, but I still blame you.
Chris, I'm so glad you moaning about the weather, because usually that's my privilege to moan about the cold weather. So, but I'm very glad you're taking it tonight. You can have it.
Yeah, Durban finally gets it.
Finally. You're looking quite cozy there, Cilna, in the lounge. Different setting this week.
I am actually. I just moved the place around, and then it turned out if I sit behind my desk as I usually do, there's a light that's going to shine in everybody's eyes, like so bright. So for everybody else's sake, it's not for me that I want to be like comfy while Bruno explains awesome things about it. It's actually for you guys. It's not for me.
Nice.
But it looks warm and looks comfy, so that's good. Bruno, how are you doing?
I apologize in advance. There is going to be a cat and a dog jumping on the couch with me. So for everybody, please just ignore it when it happens. It's bound to happen.
So unprofessional, Cilna.
How are you doing,
I've actually had consultations with clients who got upset over things like that.
Really?
Like it was barely any time out of the consultation. So like with the animal coming, like a cat coming across the screen, they weren't finding it funny. They weren't amused at all. And then the one time one of my kids came and like tugged my shirt and asked me something, and I spoke to them for like about a minute and like not impressed at all.
Really?
Yeah.
Literally, we don't do the competitive thing, and I'm not saying my stuff is better than yours. I'm just saying my clients might be nicer than yours.
Nice. Maybe my cat's just less tutor than yours.
There we go. You got a point.
My cat is cute.
Oh, guys, but let's get started with today's webinar. And got a question here that quite an interesting question, and both of you will jump onto it. It says, I borrowed my sister a lounge suite and TV, and my sister then had, she got into some financial difficulties, and the sheriff has now written up the goods, her goods, and the goods that I had borrowed to her. I don't have receipts to prove the purchase of these items that I borrowed to her, but these are my goods. Is there a way for me to claim them back and avoid having them sold at auction? Cilna, what do you feel about this one?
I feel, unfortunately, the answer is going to be if they are items of use stored somewhere, I do need to talk to two potential options. So not to the question, but just for the benefit of our viewers. If property is attached in a rental property, so I am going to move to rentals quickly, because there is something called the landlord's hypothec, and the landlord's hypothec basically states that all items brought onto the lease premises, even if belonging to a third party, is something that can be covered under the landlord's hypothec. Now, this was confirmed in a very old case, I think a 1931 case. Still, it was a Supreme Court of Appeal case. I think it was the municipality, Bloemfontein municipality versus Jackson, 1931 case, where the court ordered that any items brought onto a lease premises, unless the owner of the item expressly made it known to the landlord that that item belongs to a third party, will be subject to the landlord's hypothec. Now, to demonstrate this, if you go to a bar, now all our viewers are now going to have to rush out to a bar tonight to see what I said. On the kegs and on the fridges and everything, you will see there's a little sign printed property of SAB or property of whoever it belongs to, Erdinger or whatever the situation is. And you will now you know what beer I drink. Now that is exactly why those notices are on there. But if there isn't a notice like that, then it can be attached when it comes to the landlord's hypothec. So in a rent interdict summons, or when the hypothec was perfected in by a high court. If that wasn't the case, which it sounds like it was in this case, already a judgment obtained, and now to satisfy the judgment date, items are being attached to satisfy the judgment date. Now, the important thing to understand here is you may enter into interpleader proceedings. Interpleader proceedings, you go to the sheriff as the owner of the goods and you say, no, listen, this beautiful pillow cushion thingy belongs to me and not to the judgment creditor. But you need to be able to prove that, because now the sheriff will issue an interpleader summons. Seriously, the sheriff does this. Sheriff issue the interpleader summons, the parties come to court, and you have to prove ownership to court. If you can, and you can say, here's the receipt, here's an affidavit without any contradictory affidavits to it, to prove that these items belong to me, you might be successful. But in all honesty, if you borrow something to someone, please, please, please do make an agreement, a written agreement. Then don't try and backdate these things, because the truth about backdated things is it always comes out at some or the other stage and it's going to backfire super hard. Make a written agreement and say, the couch, the TV, this is the serial numbers, this is the photos, inventory, this belongs to me. You are just using it for the time period. If there was something like that, she might be successful in the items, in convincing the sheriff that the items doesn't belong to the judgment creditor, the judgment debtor. But unfortunately, if you can't prove it properly, chances are it will be solved by the sheriff.
Sure. Bruno, anything to add on to that?
Look, not all that much. So I totally agree with Cilna's take on the landlord's hypothec. We've had that fight. It happens a lot on commercial properties, which is typically why you find the contracts are so strict on rentals. So anything that's going to a commercial property that's being rented out to the tenant, and about making sure that the landlord actually gets informed. And I mean, that's also why then you have like notarial bonds and things like that as security, to avoid a situation like that, where the notarial bond has greater strength than a hypothec. So there I totally agree with Cilna. It's the landlord does have a lot of rights when it comes to even third-party properties. The approach on the interpleader, also so this is more practical advice. It's after the fact notion, so it's not really going to help the viewer all that much. But ideally, that's why you do want to keep inventories of the things that you own, a kind of a balance sheet, just expressing more or less what you own. People typically wouldn't do that with smaller items, and this is where the problem lies. What we need to remember is, so I've been to court before with interpleaders, where I've had to argue the matter. It's a little trial basically that takes place. So what people see on TV, where you ask questions and somebody cross-examines, it's something like that. So it's not done on paper. You actually go to court, and the magistrate or judge has an opportunity of assessing the case. And I've had also some very poor witnesses that you could see. For instance, I had a 16-year-old son who was alleging that everything in the house belonged to him and that his two parents were broke, and that, you know, that was the story. And I mean, that took very little effort on my part. I quite literally looked at the magistrate and I was like, seriously? Like, that's it, we're done here.
That's not
Yeah, so situations like that arise. So your presentation to the court's also very important. How did you get it? Maybe you've got a friend or someone that saw you with it. Maybe you've got a history. And the other thing you need to, what's that?
but don't use the kids. I am so upset with those opponents now. I'm like, see, someone, why would you use your kid like that?
Yeah,
Well,
it was quite. Yeah, no, it was quite bad, and I had to cross-examine him. But you're like, it doesn't make sense. Everything that's coming out your mouth makes no sense. How can you afford this? It's but so yeah, if you can actually show reasonably that it could be yours, and what you'll sometimes find is creditors don't want to go through the effort. Debt collection is a quick process. They're not going to spend thousands and thousands to fight over your 3,000 rand, 4,000 rand furniture. Going to court for one day fighting an interpleader is probably worth more than that. So I sometimes find if the interpleaders over items that are very little value, sometimes it's more feasible to write it off and move on. Because eventually the guy's going to run out of items to do that with, and you can only lie a few times. If it so happens that you execute against them and 2-3 times later there's all those interpleaders, then the court's not going to buy the story anymore, and you can actually use all of this as evidence. So yeah, maybe try with an interpleader, but no promises.
So my mother's not a lawyer. She's never been a lawyer. She doesn't know anything about the law. But she's been doing this for years because she writes her name on all her Tupperware containers that she borrows out to my aunts. So if the sheriff comes and knocking, best believe my mum's name on those Tupperwares still now.
Well done, Mrs. Abrams.
Yeah.
I like that. I like from now on, if I give anybody anything to anybody, if I borrow anything to anybody, I'm gonna Cilna Steyn.
Yeah.
And
Sure, date.
no, thanks. And yeah. Thanks, guys. Let's move quickly over to the next question. And this question says, my tenant is originally from overseas. The lease has come to an end and he subsequently has moved out of the property. I've never had any issues with this tenant. He's paid rent on time and he didn't damage the property when we inspected it upon his exit. The problem is I can't get hold of him now, and the reason that this is a problem is because he's left a few items in the property, well, in the apartment: a couch, kettle, a TV stand. Not too many items, but there's still items there. He hasn't given me any indication of what to do with these items, and the last I heard, he was actually out of the country, and there's probably no prospect of him returning. I don't want to pay for storage for these items. I don't want to use the items either. What can I do legally in this particular case? Bruno?
Sure. So it's never an easy question. Number one, it rarely ever happens. So this is like 1 in a million situation here. Typically when it does happen, so if you look at that let's put it this way. If you look at the situations when things like this do happen, there's always some money outstanding. There's always some form of justification where you could potentially go to the court, institute an action, get default judgment, attach the property, sell it, and just get rid of it and kind of move on with your life. So when it does happen, that's the typical scenario. So it's never, to me, happened in a situation where the person doesn't owe anything. It's almost like they abandoned their property. So to begin with, if there's any indication at all where the guy said, oh, I don't want it anymore, I'm leaving it, that's probably the first thing that you'd want to try and investigate. Go speak to the security guard outside and ask him this, because if that's the case, then guess what? He just abandoned it and donated it to anyone that wants to take it, right? If that's not the case, and he literally left and he just left it there, Cilna and I had a brief discussion about this. A genuine attempt should be made to try and reach out to him out of courtesy and make the suggestion that he come and collect it, and obviously place some sort of ultimatum. So to say, listen, if you don't collect it, we're going to dispose of it in this way. What I genuinely like to do is I also look at it very mathematically. If the assets are on the property and it's difficult to get someone to occupy the property while the assets are still there, the reality behind it is there is a level of damage that's being suffered, because now you can't rent out the whole property. So you can't just now claim it and say, well, it is what it is. But the reality is mathematically, there's a sort of a set off that you're looking at now. So I would also include this in the letter just to explain, look, the fact that it's there means the tenant can't move in. This is the value of the rent that's accruing over this period of time. So mathematically, you're causing yourself damages. If this thing stays there even 1 day or 2 days or a week, it's going to, it's going to cause damages of this amount or whatever the case is. So you might just want to point that out for the sake of the person being aware of this. And at this instance, and this is where the difficulty comes in. In this letter, you give the ultimatum and say, if you don't receive a response within X period, you're going to do something with this property. And this might typically be, just to donate it or give it away or whatever the case is. It is a bit gray. I'm not always comfortable with that. So I always tell my clients, be cautious. If there is a way that even if it gets used, the guy left it there, he knew that new tenants were coming in and it gets used, at least it's still there. If he ever comes back and starts kicking and screaming, it's like, take it then. But we're not covering you for it because the cost of it being here is the fair wear and tear.
Thanks, Bruno. Cilna, anything to add on to that before we move on to the next one?
I don't think to Bruno's, I think his was absolutely on point. But what I do want to mention is, if you do not have the lucky 1 in a million case where the tenant has paid up to date and the whole thing, let's talk about a tenant that just absconded. And so in terms of the Rental Housing Act, a tenant that absconds, the lease agreement is deemed to have been cancelled when a tenant absconds. But they leave their stuff, and it's always... I'm trying to be diplomatic, that's what I'm thinking. If people don't leave nice things behind, you like your nice things. So the stuff you're leaving is that microwave oven that you like, what happened inside that thing? I would love to hear the stories. This microwave knows stuff that he doesn't want to, or a kettle that's like, he's not going anywhere. People don't leave nice stuff. In this particular case, I can see how that happened because it's somebody that lives abroad. It costs a heck of a lot of money to get containers and stuff. So that makes sense. But in the majority of the cases, the stuff that's going to be left behind, is that one bicycle, you catch my drift, the golf set that still has like severe interesting shafts. That's the stuff that you leave. What I recommend in those cases where the tenant absconds is to do a letter to the tenant and notify him in every possible way. If you have a cell phone number, send a WhatsApp, but for good measure, just send a Telegram message as well, just in case this person is scared that Mark Zuckerberg's checking his mails. Peace out, Mark. You're probably seeing this. But all those things, send an email, send a notice, deliver a notice to the door, attach it to the front door. Do everything you can to get this reasonably to the notice of this person. Give him a reasonable time. Let's call it 7 days, 14 days to come and collect the items, and tell him, if you do not, or if I do not hear from you, I am going to move these items into storage for another month, and after that, I'm going to donate it to charity, or skip the whole thing and say, if you do not make contact with me in the next 7 days, 14 days, I am going to get rid of these items. I never recommend taking it then and using it yourself unless you can use it properly and return it safely. But give it away, give it to a charity, whatever, so you get away from the risk of theft. Because remember, theft has an element of purposeful action of stealing the stuff. So you get away from that, you make it clear that you don't have a choice. If it is expensive items, I would be much more careful. If it is something that's actually worth something, I would be much more reluctant to just randomly get rid of this stuff. Then I would probably consider storage, and then at a later stage issue summons for the storage fees, and then sell the items to cover the storage costs. But please don't take our advice that we just gave as a standard set advice right now. This is super case specific, and you can end up in a criminal situation if you do not do it right. So this is not one of those DIY things. Just keeping our viewers out of jail here. So please don't say, Cilna and Bruno said, in some cases you can do it, but you need to be very careful. Rather just check with your attorney before you pull a move like that.
No, thanks, Cilna. Bruno, I think you're on mute.
I had a case once on a so different scenario. It wasn't about leaving things behind necessarily, but property was bought by my client in a sale and execution. And when they went knocking on the door, there was no one there. The property was completely abandoned. No one could actually live on this property. There's a couple of things there, like a bunch of old stuff. And they just, they actually called the estate manager and they asked, listen, where do we put it? They put it in a little storage room. They didn't know where the guy was. And now this was about a 60-year-old woman, 70. So my client was the son, but he was based up here in Joburg. So she was up in Neisner. And so not a young woman. So like she had no intention of stealing. She's solid. She's got money. She's good. And this guy came back and said, apparently there was like 100,000 Rand bottle of whiskey there that now is gone. And he laid criminal charges and the NPA prosecuted her. It was madness. Like we even had a SC to do the appearance there in I think it was Niza, if I'm not mistaken. But it was madness because everyone knows there was no bottle of whiskey there. No one would have abandoned the property with it. But he had a list of things that apparently she stole. And this woman had no reason at all to steal. So be careful, because sometimes then you need to look beyond the honesty aspect. Because sometimes you're very honest and it's like, oh, great, but it was a small thing. I didn't do much with it. Oh, it's of little value. What difference does it make? Let me just put it aside. And then you find out that the person comes and starts saying that that was an antique, from the French Revolution worth R1 million now. And you're like, oh, okay, it was an ashtray. It looked like an ashtray. I smoked. I put cigarettes in it. I don't understand.
Oh man. No, but thanks so much, Bruno. 100,000 Rand bottle of whiskey.
Yeah, I'd love that bottle. I don't know. I can't remember. It was something stupid, like you couldn't believe it. I don't even know. Yeah, who would? Yeah, no, it's madness.
Anyway, I would have drank it just for the record. I would have. But nevertheless, let's move on to the next question, which was asked by Ricky Khan. Ricky is an avid viewer of ours, and Ricky, we really appreciate the questions that come through from you. The question goes, around the end of a lease, what is the landlord allowed to use your deposit for? And are there any limitations? So for example, does the landlord have to get 3 quotes for a particular job that he's going to do on the property in terms of utilizing the deposit? Cilna, I'm going to give this one to you and you're just going to go with it.
You can see I'm already excited.
Yeah.
It's one of my favorite questions. And whenever I do training for estate agents, this is one of my favorite topics because there's this thing about deposits. And I always wonder, it's actually a very simple part of the law. The Rental Housing Act, Section 5, is very clear. It says, deposit must be kept in an interest-bearing account. Deposit may be used for anything that the tenant is liable for under the lease agreement that wasn't paid, or any damage that was caused by the tenant, hence the requirement of the incoming and outgoing inspections. So it's not really that complicated, but I've seen people complicate deposits on a level that I'm thinking, oh my goodness, thank goodness, I just keep it simple. There's no provision anywhere in our law, not the Rental Housing Act, not the regulations to the Rental Housing Act, nothing of those legislation or regulations or anything says anything about the tenant having the right to sort of approve what the landlord's going to do. I'll say it less diplomatic, as I sometimes say other things. It's not the tenant's call to make, it's the landlord's property. If the landlord if there was an incoming inspection, exit inspection, we can clearly see there was damage caused to the property by the tenant. And the tenant's on his way out. So if the tenant has to say there's damage to the paint, so we need to repaint, the tenant is going to paint with any paint that is not like proper expensive paint. You guys know I always have a fit about paint because paint is really not created equal. The landlord is going to want to paint with a good quality, washable, proper paint. The tenant's going to want to paint with the cheapest thing that he can find. Obviously, he's not going to live there. So this is why the Act doesn't give the landlord, the tenant, the right to have any say around the repairs. The Act says the landlord must provide the tenant with receipts. Receipts means he already paid. He decided on the quote, he paid. A receipt comes after payment, so never mind the quotes. The landlord must provide the tenant with the receipts of the items that was repaired and then deducted from the deposit. So it's very clear that the Act doesn't require or doesn't give the tenant the right to see any quotes before the landlord attends to these repairs. The Act, however, does say that the landlord may only deduct reasonable repair costs. So what's not reasonable is if the property was painted with a bad quality paint, the tenant moves out, he caused damage to the walls and we need to repaint. The landlord can't go and now charge Plascon double velvet paint to the tenant. Yes, that's my paint. I have a paint brand. I do. Plascon, yay, hashtag. I should be an ambassador, apparently. If the landlord then decides to use the tenant's money to do something better than there was, that is definitely unreasonable. And the landlord can't do that. But within reasonable parameters, the landlord is entitled to use the money from the deposit for anything that the tenant is responsible for under the lease agreement. So be it outstanding rent when the lease ends, be it repairs to the premises, be it utilities that wasn't paid, whatever the case might be. And in the case of an eviction, even the legal costs for the eviction. Yes, I just said tenant can pay for his own eviction from the deposit. So anything that the tenant is responsible for under the lease agreement can be deducted from the deposit. Ricky, I hope I've made your evening.
I'm sure you have, Cilna. Actually, that was a really, really good answer. Bruno, anything that you wanted to add onto that? I mean, Cilna's given so much already.
No, that was good. No, I'm
Yeah.
fine. That was 100%.
Very good. But now can we maybe like approach Plascon, like get them to sponsor these videos or something, please? Cilna really loves it. Is that Plascon behind you, Cilna?
It's not. It's not.
Was that a tenant who painted that?
I had nothing to do with this particular paint.
Oh man, thank you so much, Cilna. Thank you so much, Bruno. That brings us to the end of tonight's webinar, and it's a pleasure having you, the viewers, with us. Please remember to drop your questions in the comments below or on the group itself, and we will deal with them next week when we see you at 6 o'clock. Thank you, everybody. Thank you, Cilna. Thank you, Bruno. Cheers.
Thanks, guys. Cheers.